wasn't able to attend the Northeast meeting last year, but I'm very happy to be here again this year. It's a tremendous venue. I can't tell you how excited I am to be here with all of you and to be enjoying this wonderful room and this nice hotel and the great exhibits and all the sponsors. For all the people who organized the meeting, congratulations. You've done a fantastic job. Why don't we give them another round of applause. Okay, now I'm going to try and use the, yeah, okay, it works. Excellent. Now, is there a laser pointer on this? Sorry about that. Okay, perfect. All right, now, I tend to like thinking about big picture topics. If there's any sort of a theme with regards to patent informatics and what I've been writing about, it's trying to look at the big picture, looking at ideas and issues that concern the patent informatics or patent analytics community that probably need some more discussion and some more research. So I've looked at various things such as looking at citations in general. We started off with a post that talked about how many citations does a U.S. patent have and whether or not we should be reconciling that with the pre-grant applications. I talked a little bit about that at the annual conference. We've talked about patent families. There's been a number of posts on that particular topic, including 3 just recently, about whether or not extended families are the right way to do patent family reduction, or whether using various vendor patent families is a good way to do it, or my own personal mechanism, one document per invention. These are big topics that have huge impacts on this type of statistics that are being done for patent analytics and don't necessarily get discussed as frequently as they ought to. And so that led to this particular series of items, looking specifically at the U.S. and trying to differentiate citations that are coming from the applicants versus those that are coming from the examiner. Now, everybody's heard a lot of different stories about applicant citations. And the fact, for instance, that some applicants will simply unload everything they know about, whether or not it's terribly relevant or not, into an information disclosure statement or an IDS. And it's not that uncommon, I'm sure everybody's seen it, where you'll see a U.S. patent with 300 backward citations. Okay? Now, there's really no chance that all 300 of those are really, really relevant to the invention at hand. But for various reasons, they want to make sure that they're comprehensive, and they include them all. Now, on the other hand, we've often heard from our colleagues in Europe and from other places around the world that because there's no duty to disclose, that the citations that are coming from those offices, which are coming directly from an international search report or from the examiners themselves, are of perhaps, let's say, a little higher quality because they're coming from an examiner and not coming from an applicant. Now, I'm not going to stand up here and argue one way or another. I think all citations are important. They can all be used in a variety of different circumstances. And frankly, since there are 4 talks today on citation analysis, I think there's probably some agreement that it's a pretty powerful technique and one that people ought to be using. I'll also apologize ahead of time. I have to leave after the break, so I won't be able to see some very excellent talks this afternoon, and I apologize to those authors ahead of time. Certainly not because I didn't think that the material was well worth staying for. So some of this is very much review. I'm not going to spend a ton of time on it. There are different types of citations that are associated with U.S. patents. Some come from Form SB08, otherwise known as an information disclosure statement. Others come from the examiner. Those are on Form 892. And then yet others are coming from a variety of other sources, including third-party submissions, which is a relatively new thing. And you're going to start seeing those showing up in the cited references section on PAIR as well. So as I mentioned, the U.S. is a little bit unique in the sense that there's this duty of disclosure. And I'll leave this for you to read. But this is coming directly from 37 CFR, which talks about the duty to disclose, and from the Manual of Patent Examination, Examining Procedures, the MPEP, that the office encourages the applicant to carefully examine and provide all of these different references. Now, things have changed very recently where inequitable conduct will not be an issue going forward, so that's something. But again, generally speaking, applicants are using IDSs to provide citations, and sometimes they're quite relevant, and they're quite focused, and they're quite on topic, and other times maybe not so much. Okay. So even though the office says that they require the applicant to provide the closest information, again, they can be quite lengthy. And again, as I mentioned before, I actually am a big proponent of citation analysis. I think it comes in handy very frequently when you're talking about licensing and you're talking about sales of patent documents. And so, but at the same time, I also know that it's very powerful to be able to say to somebody, well, you originally filed a patent application in this particular technology area. You ran into a 102 rejection based on my patent that is now granted at the time maybe it was in the application stage, and you therefore abandoned your application after putting a significant amount of money, say, into a research program. And so if I'm armed with that information, when I'm having a conversation with you about licensing my documents, well, I have ready-made evidence to demonstrate that you probably had an interest in it, you probably would have had an interest in it in the future, and therefore it's going to be a more fruitful conversation, hopefully. And so in particular, being able to separate the examiner citations from the applicant citations in the U.S. is pretty critical and not terribly easy to do. Okay. Now, once again, the examiner citations on these U.S. documents are likely to be closer to the source material. Just sort of looking at this slide, the Form 892 referred to as the list of references identified by the examiner, so these are the specific examiner citations, represent the prior art used for various office actions. Okay? So, but it's not just the office actions. There's also these references that the specific item in each of the office action reports in pairs say made of record but not considered. Okay? So this would be in the parlance of the international search reports and of EPO reports and so on. This would be more like an A-type document where it was considered but it wasn't actually used for a rejection. But having just been considered, it's generally still pretty well on topic. It's pretty much, it's not a 102 or a 103, but it's almost certainly very close to the subject matter of the source document that's being examined, and so much so that the examiner put it into the made of record in the formal examining documentation. Now, so the bottom line is that in the case of Form 892, or the list of references provided by the examiner, these are hand-picked. It's a very short list, by no means comprehensive. So vice versa, if you're looking for every citation to anything that's at all relevant, well, we all know that here in the United States, that's not the way it works. There is just enough searching done, there's just enough art cited in order to be able to write an office action and be able to get a response back for the purposes of examination. It's not meant to be comprehensive. And so it's not going to be. And that's not the point. So keeping in mind exactly what the purpose of these citations are, how the examiner is using them, is pretty important. And all of this data can be gotten to using the Display References tab when looking at the case in U.S. Public Pair, but quite frankly, that's an enormous pain in the ass. Because you have to download all of them, and they're not even really in computer-readable format, and it would take you forever. It just takes a long, long time. And in some of the subsequent slides, I actually give some additional, it used to be even worse. It used to be that this would have been impossible. And it used to be that they didn't put asterisks on the examiner citations versus the applicant citations. So you could never tell which were which. So this has been a work in progress over the last 10 years, where we've gotten progressively better. And again, the USPTO is not even giving us really solid, good information to the point of even identifying 102 versus 103. You'll see in this discussion that there's actually a third-party vendor that's gone out and collected that information, and they're providing the 102 versus the 103 versus the made of record. Okay, so it's not even coming from the USPTO, which means it's impossible then for the people who build databases who are getting this information from the USPTO as the source data to be able to flag that for you. So while I'll be talking about data sources from the vendors in a moment, they can't get into the same level of detail that you can get into when you get to this Patent River product, simply because that's not what the Patent Office is providing. So the Patent Office could do a little bit better job of supplying more rigorous detail, at least, on this source data. Okay, so in order to work through these various issues with regards to teasing out examiner citations versus applicant citations, I did two different things, and they're in the form of a case study. All right. Now, like I said, this has been a progression of stepwise items. First, there are backwards and forward citations, so I went ahead and explained some of that. And then from there, there's a distinction between just being able to separate examiner from applicant. And that's step 2. And then step 3 is the ability to then be able to say, well, with the ones coming from the examiner, which ones were actually for 102 and 103, which we heard from this morning. So that's the progression of steps that this particular post is going through. So we're starting at the very top, and we're working our way down to the real nuggets, the real gems, the jewels in any of these citation analyses. So in this particular case, I looked in Thomson Innovation for Allure Energy, which has U.S. patent documents, 10 grants, 29 pre-grant, total of 39 documents. 28 of these have at least one forward patent citation associated with them, according to that particular database. I picked this one because all the case studies I do are usually somewhat whimsical. This particular case, they're suing Nest, which are the people who make, the people from Apple that started a thermostat company, and they have these fancy $250 thermostats. And because it's an Apple-related thing, I was immediately interested in it. And I thought it was cool that there was this litigation going on, and so that's why I picked it as an example. Okay, but first, they need to be reconciled. And I can't say this enough. And it's starting to get some traction. I'm starting to hear people, some of the database vendors and the producers, starting to address this issue. Because up until just recently, it wasn't an issue in the U.S. There was only a U.S. publication upon grant. That's what got the citations and the store. Nobody was talking about the equivalence, especially the life cycle equivalence, going from a pre-grant publication to a granted patent and making sure that those are reconciled, because it's the same document. Okay? Now, technically it's not. It's got a different number. It's got a different kind code. It was published at a different time. So I could always understand from a certain point of view that, okay, yes, they are discrete items. So I have no fault with the people who build the database for keeping that information separate. They are discrete items. Got it. But in reality, it's the same document. All right? Now, yes, I know. The claims changed upon examination between yada, yada, yada. It's the same document. It's the same invention, the same application number. Okay? They ought to be reconciled. All right? I really don't think somebody will be able to convince me that there's a really strong argument to keep them separated routinely. Now, if you want to keep part of the database, just like, enhanced versus original, it's very possible to build fields that say, okay, this was the citations to the document all by itself. These are citations to the document either at the family level, which I also don't like because I don't like expanded families, extended families, or equivalence. Just bottom line, basic, same application number, no other equivalent definition necessary. But all of the documents that have the same application number, here's the citations associated with them. So in case of these 10 granted Allure Energy patents, all 10 have pre-grant applications associated with them, which we'd expect because of the age. They're relatively recent. In only one of these cases, though, both the granted patent and the corresponding pre-grant application don't have any forward citations. And in 3 of the cases, the granted patents have no citations, but the corresponding pre-grant application does. So here's a table, and this points this all out very well. Granted patent 0000, corresponding pre-grant application 2, 4. So that's the example where they're both 0, 3, 4, etc. Okay? So this is the reconciled total. Big difference. 24 here versus 33 here. Okay, well actually I don't even total, that's just 24 for that last one. But notice that most of these are zeros and most of these are not. So if you don't reconcile them, you're automatically off. The companies that are being represented, the total number of citations associated, and these are just straight equivalents, pre-grant to grant. Nothing family about it, nothing else, just that.
So that's 41 to 33, though.
41 to 33?
Yeah.
Okay, well, there you go. Thank you. Okay. Now, in this particular case, another one of the things that I like doing is I use this tool called OpenRefine, which is also called Google Refine. It started like as Google Refine, and it became OpenRefine. It's a really, really great tool for doing a lot of different things, including manipulating data. Now, while I'm mentioning Thomson Innovation in this particular case, it was a convenient source of this data. If you can get the data that I'm going to show you in these couple of slides from just about anywhere, then you should do so. This is not about Thomson Innovation. This is just the fact that they have the data in an available format. And it's called the Citing Reference Details patent field. And for one of the patents, it looks like this. That's the citing patent record, and so on. Actually list out what each of them are. So the 065 patent has 3 forward citations associated with it. In this case, they're separated by a vertical bar between each of the individual discrete items. And then within each entry, you find 6 pieces of information associated with each of the 3. So this is a single cell in an export in Excel format. Okay? 3 discrete items with 6 individual fields all in one cell. Tremendous amount of information. It's impossible to work with unless you tease that apart. And so what we're going to do is we're going to tease it apart by creating new rows for each of the entries, the 3 cited documents, and then we're going to create new columns where there are commas. And when I create that new column, one of those columns is examiner versus applicant, and I can get to which ones are coming from the examiner. Okay, that's the whole purpose. That's the bottom line of this. Okay? So like I said, they represent the citing patent number, citing patent country, type of citation, and that's the one we care about, examiner versus applicant. If there are international reports, which there aren't any in this case, you also get the X and the Y's versus the A's and so on. So you get the notations coming from the ISAs and the ISRs. And then the application date and the citing patent applicant. So you can even figure out who are the companies that are doing the citations. Okay. So once you've exported this, you need to create a CSV file out of it, and then you can bring it into OpenRefine. But first, what you have to do is, remember, you need to reconcile. So actually, I should go back. There were 3 associated with the granted patent and 7 associated with the pre-grant application. So the very first step was to take and merge those cells, which is relatively straightforward to do. You simply copy and paste the data from the pre-grant application, paste it onto the end of the data associated with the corresponding granted patent. So you're just copying and pasting it into the cell that had the original data. And remember to include a horizontal bar after the data in the granted patent, because that's what's going to be your separator. Now it looks like this. So the 605, after it's been reconciled, this is all the data. Now, I will also tell you that DPCI is now part of Innovation, which gathers all of the citations by Derwent family, and the corresponding field for exporting, if you took the DPCI family field, as opposed to the discrete record fields, would put these together for you. So just as something to keep in mind if you do have DPCI. Yeah, James.
Would this also have journal articles in the international reports?
There's a separate field for citing reference details non-patent. So there, yes, absolutely, and it's kept in a whole separate column in a different field.
So a similar process would be helpful, possibly.
Oh, absolutely.
Yeah, great.
Yeah, and the whole point is that this is not workable. You can't do anything with this. You can't sort on this in Excel. You can't tease out examiner versus pre-search versus, you can't do anything with it. So in my case, I take it into OpenRefine so that I can then go ahead and do this kind of stuff. This is bringing it in, okay, and then it's got the information here. comma separated in this case. Don't read the top line because that's the header. Okay, and then I want to transform. So here under facets, so citing patent first assignee, edit cells, split multi-value cells. All right, and you tell it I want the bar, the horizontal bar, to be the separator, and it does that. Now there are new rows. We went from something like 39 rows, because that's how many we had, and then we went to 147 rows, because every discrete citation value now has its own row. Then again, edit cells, fill down, so that's filling in the number now, so if I need to get to that later. And then finally, split into several columns. So I'm taking this, again, this citing patent first assignee content, and I'm going to go ahead and split that into separate columns so I can get to each of the items. And then just for cleaning up purposes, I can rename the column for citing reference detail patent 1 to citing reference detail patent number, patent country, citation type, patents assignee, and so on. So I just rename the column so when I'm working with them later. And then if I look at that one column that talks about where the citation is coming from, I can see very clearly pre-search are examiner citations coming from pre-grant applications. That's what 7 means, and there's 90 of them. And a 0 is also from an examiner. There's 33 of those, and so on. So these are all listed, and I've got the numbers, and I can see that almost all of them, except for this one for applicant and this one for other, and then this is the X and the XP and the Y and the A. Those are coming from the WO documents that correspond. Okay, but I can group these together fairly easily to get total numbers for each of the different examiner citations. But I'm really only interested in the ones in the U.S. So I'm going to use the 7s, the 0, the 11, and so on. And I can look at which companies are associated. Again, if I'm looking at this as a mechanism for saying, I want to go and have a conversation with somebody because their patents have gotten an office action, an adverse office action, because of something that I have for sale, I have evidence now to demonstrate exactly what happened here. And so in this case, Verizon, surprisingly, has a very significant number of examiner citations, not applicant citations, examiner citations. Same thing with GE and Sony, and we get the Nets down here even as well, and Rockwell, and so on. It's a very nice list, and these are all examiner citations. So these have that extra bang for the buck. Now, like I said, there's a difference. I mean, now, the international search reports that come on the WO documents and the EP documents and so on have the X and the Y. You don't have to tease it out. Now, I could get at it from the data that I got out of innovation, but that's actually, you don't have to do anything special with it. It comes automatically. And the difference between an X versus a Y is essentially the difference between a 102 and a 103. So we'll talk about this. So while U.S. doesn't have X and Y documents, there are different types. There's the 102, and I'm not going to bother to read this. You can read this yourself. I'm also running a little bit short on time. And there's the 103s. Okay, and they're basically equivalent. So X documents speak to 102. Essentially, all by themselves, they invalidate claims. Y documents, traditionally, they have to be used in combination with something else. Normally, in the U.S., that's the same as a 103. All right? And so, but you notice I couldn't get any of that data from what I got from innovation. Again, not Thompson's issue, because they can't get it from the patent office. USPTO is not supplying this. So, what does that bring us to? Well, like I said, these are not available. You could get them from public pair. But recently there's been a service called Patent River, which is, they're doing something that they call these blocking citations. So if a citation is keeping somebody from being able to get a patent because of a 102 or a 103 rejection, they call it a blocking citation. Or a forward rejection. All right? Now they've basically scraped public pair, taken down all those documents, OCR'd them, and recognized when something is a 102 versus a 103. And they're making that available in reports that you can buy directly from them or through Pantros IP. Okay? So in this particular case, I asked them to send me a report for the Allure portfolio, and they did that. And it provides which Allure Energy document led to the rejection, the assignee at issue, applicant number at issue, current status of the document, provides the type of rejection, when it was generated, whether it was final or non-final, whether the claims were amended in response, and if the rejection led to an abandonment. Unbelievable amount of really useful information. So you just sort on this column. I just want to see the 1 or 2 rejections that led to an abandonment. Short list of people to call up on the phone. You spent X tens of thousands of dollars to apply for a patent. You ended up abandoning it because of our prior art. How would you like a license? Honestly, I mean, and I can tell you stories about non-patent entities and the whole trade of intellectual property and licensing and selling and buying of patents. And believe me, people, this is what they do. Okay, this is what happens. And then, if that wasn't enough, they actually give you a link to the specific office action, the exact document that is being that caused that data to be generated. And you can get the applicant's response and the amended claims. And there's an example of what the report looks like. Again, current status, where it was in the portfolio history, what's the rejection type, and so on. Okay. So as I mentioned, over the past decade, U.S. has begun to slowly move to a point where you can at least distinguish, in some senses, examiner versus non-examiner sites in various other items, but there's still a long way to go. And so using data from a variety of different sources, it is now possible to begin putting together a very distinct separation of the examiner sites versus the non-examiner sites, and then from the examiner sites also be able to look at the ones that were causing rejections either all by themselves or in combination with another reference. And with that, I think I'd like to thank you for your time today.
The question over there.
You can take one.
Yeah, I only got 25 minutes, but we have to make the question.
Yeah, you're good.
I'm going to keep it. Steve Schreiber with Pfizer. Thanks for another great talk. I'm curious, so to get this information you've got, Patent River, they clandestinely scraped the site, somehow getting around this confounds the rest of us. Well, I'm sorry, I meant went in and manually got all this information. That's great. Now, Reed Tech has this whole initiative. Is there any word from them on implementing any of this, working with the data? They, in theory, have all this in a legitimate and more robust and complete and current way. Are they? And if not, why are they not working with something that should be? It would make so much sense to do.
Yeah, and I think they are, and they've done it. See, they have to be very careful because Reed Tech has a couple of different businesses. Okay, Reed Tech works for their biggest customer is the patent office for working with patent documents to begin with. All right. Now, secondly, they bought another service that they call Patent Advisor now. Okay, and Patent Advisor was doing the same scraping. But they weren't quite focusing on 102 and 103s. They were doing something else. They were just making, and they've launched a product. I wrote a blog post about being able to search pair records, the electronic pair records, using Patent Advisor. But they're trying to walk this fine line between upsetting the patent office. And the funny thing about Reed Tech is even though they have the contract with the USPTO, they have to go off hours and grab the data from the existing systems the same as everybody else. They don't get the documents sent to them by exactly. Funniest, weirdest thing I've ever heard. They actually, and they have to do it at night, and they have to do it at off-peak times, and it is the screwiest. You wonder why Google isn't doing this anymore. Well, part of it was because the USPTO is still not making this easy, especially when it comes to the electronic images, with the electronic file wrapper contents. So yeah, so I think they're working on it. So
Sorry, just a follow-up. Are they facing conflict because they've got the commercial service and the PTO contract and?
Yes, because they would just as soon not upset the USPTO. And so they're trying to make it functional, they're trying to add capabilities, they're trying not to step on too many toes. It's a very interesting dance. James.
Hi, James Grant from Artist. Is there a way, using what you've described, to identify X and Y citations before a certain date?
Yes, I think so. It would be best to talk to the individual data vendors, but X and Y documents are actually coded in the databases. So they're part of the search fields. So the one I use, the cited reference details patent, is not a searchable field on Thomson Innovation. Okay, but there are other fields where you can put in X, and it will search for just the X documents, and then you can and it in with a appropriate year field or date field to make sure that it's coming before a certain date. So yes, with the X and the Ys, because the electronic data is available, it's very possible to do that on most systems. You're welcome.
I think we should continue.